This is the Investor Connect podcast program. I'm Hall T. Martin. I'm the host of this show in which we interview angel investors, venture capital, family offices, private equity, and many other investors for early stage and growth companies. I hope you enjoy this episode. Hello, this is Hall Martin with Investor Connect. Today we're here with Brian Burkinshaw, founder and owner of Clearpat Services. Clearpat Services is a technology commercialization firm specializing in concept research, evaluation, patent novelty, clearance, and accelerated searches, drafting and prosecution of patent applications involving mechanical, medical, and biotech devices, technologies, and processes. Among their specialties is the ability to help you protect your valuable ideas and help you guide you to market commercialization. Their niche is in helping small to mid-sized businesses and individual inventors in Austin and Central Texas are obtaining patent protection for their ideas while keeping costs to a minimum. They can perform the research necessary for patent planning to determine how best to protect your ideas, whether it's through trade secrets or the generation of patent applications that stand the best chance for patent allowance and issuance. Implementing the right strategies can place your company in the best possible position to be favorably considered for growth, venture funding, or acquisition. Brian has over 40 years of experience in industry ranging from product design, manufacturing, and project management to venture capital. He's also named inventor on over 50 patents. Brian, thank you for joining us.
Well, thanks for having me, Hall. Good afternoon. I'm glad I could be here.
Thank you for joining us. And so let's start right at the top. That one of the most often questions I get is, when should a startup file their patents?
Well, I hear that a lot as well. One of probably the best things you can tell somebody is file early, file often, and before you show it to anybody else. Typically, a lot of people will go out and try to demonstrate their idea to their friends, and they'll take it to a conference or they'll take it to some kind of a meeting, a professional meeting. They'll pull this thing out of their pocket and say, hey, what do you think of this? And they've never filed a patent on it. And what they've done is they've just exposed their idea to God knows how many people. If they do it at a conference, it's public information at that point. And they basically cut themselves back in terms of their ability to file a patent. There are some rules that allow you a little bit of time, a little bit of leeway, so that even after you've disclosed it, you have a certain amount of time to file. But if somebody beats you to the punch, because now since 2011, we're after the America Invents Act, the first person to file is the first one to get the patent. It doesn't matter anymore if you're the first to invent. Always file before you show it to anybody.
Great. And so what should they file? What's the strategy there?
Well, again, as anybody will tell you in law, it depends. Very rarely does anybody have a concept that is so well thought out where they understand the market, they understand everything that's going to happen and how it's going to be received in the market. I always recommend the first thing to do is file a provisional. What that does is that gives you a stake in the ground, gives you a priority date, which is very important, and it says that from this date that I file, I've actually disclosed my invention to the patent office, and it gives me a full year to perfect those ideas before I have to file a utility patent, a patent application, I should say. So maybe I should back up just a step here and clarify some things. One of the things I hear all the time is, I've got a provisional patent, and nothing could be further from the truth. There's no such thing as a provisional patent. A provisional patent application exists, and that is what I'm talking about, filing a provisional patent application. Then you have a year to file a utility patent, which is the thing that can actually evolve and turn into a patent down the road after it's been prosecuted. But the provisional application is what puts the stake in the ground. And these are the things that I'm talking about that should be filed early and filed often. They're cheap. They're quick to write, relatively speaking. Depends on how you write them, but people have different ways that they like to write their provisional applications. But the rules aren't as stringent on a provisional. They don't require claims, and there's a number of formalities that don't have to be done. And they're, as I said, relatively inexpensive. They're like $300 to file with the patent office, not counting the legal fees that somebody's going to charge you to draft those. But again, even if you choose to write those yourself, you just have to be careful that you do it in a certain way that it fully discloses the key nuggets of your invention and what it is without going into a whole lot of detail and what I like to call a kitchen sink dump. You don't want too much information in there because, like they say, anything you say can and will be used against you by the examiner. It becomes anything that you put into a application becomes prior art down the road. So some little things to keep in mind there. There's a lot of information that comes out of that, but that's one of the things that you need to keep in mind when you're doing that.
Great. So how should an investor value filed patents? How much stock should they put behind that?
Well, first of all, as an investor coming in, I know that you, for one, probably always ask, do you have any IP? Do you have any patents? Do you have any trademarks? Do you have anything like that that is considered IP? First of all, that tells you that whoever you're dealing with is serious. They've thought it out. They value their technology enough to have taken the time and the effort and the expense to go ahead and protect their idea. It says that they're a little bit more than a weekend warrior out there playing with an idea. But when you take a look at that patent or that trademark or the design or whatever it is, you've got to look to see, first of all, is it enforceable? There's a lot of things out there known as paper patents. They merely describe the technology, they describe the device, they describe things, but the claims are so poorly written that you can't enforce them. You'll spend a lot of money, a lot of time getting that patent, and it's essentially worthless because you can't enforce it. And by that, I mean, they may be written so broadly that they're like blue sky claims. And you're taught to do that early on with your first patent. We have just a couple of claims, and you write them as broadly as possible just to see what kind of feedback you're going to get from an examiner. And then that'll help you whittle it down and then hopefully get you to the key nuggets that are in there. But once you get to the key nuggets, then you've got to write them so that they are enforceable, and that you don't have something called divided infringement, which essentially means that it takes 2 or 3 actors performing a task that the claim describes. By that I mean, say, for example, you're providing a medication for a disease. Okay, well, who made the medication? Who delivered the medication? And how was it prescribed? And was it the doctor that infringed it? Was the salesman that infringed it? Or was it the company in India that made it? So you have to be very careful about how you write that claim. So you have to look at whether or not they're enforceable, whether they're targeted claims. Are the claims going specifically to a unique feature that has to be there and that is very easy to see when you go look at whether or not somebody's infringing your idea? And you have to be able to prove it. So the best way to prove it is, does it look the same, act the same, machine the same? Can you open it up? Does it have the same mechanism in there? Does it function the same way? Is the process for producing something, can it only be done at a certain way, at a certain temperature? Those types of things. So you have to be very specific about how the claims are written and how enforceable they are. So that's how you look at the value of it. If it's written so broadly, blue sky type of claims, or they just have divided infringement throughout all the different claims, then they're not really as valuable as you might think. The other thing for somebody, for example, that's somebody that buys and sells patents, an NPE, for example, what they're going to look for is what makes a patent unique is your ability to keep others from practicing your idea. And so for them, it's strictly a monetary tool. It's something that they can license or sell to somebody else. And if you don't have that enforceability, it's not valuable enough for them to license it or sell it. So in a nutshell, that's what I would tell people to look at in terms of how you value a patent.
Okay. And so that's the difference between what is a valuable patent and what is not so valuable is enforceability.
Correct.
And so what should you file as a patent and what should you keep as a trade secret? How do you make the distinction between the two and making a path there?
Sure. Trade secrets are, well, let me put it this way. Patents are the things that have a lifetime to them. And they're typically the things that if you look at a device or you open up a device or you look at a process, when you can readily ascertain when it's sitting in front of you what it is that they're doing that makes that a unique, patented invention, then it's not something that's hidden. Then it's something that should be patented. If you can't keep it hidden, then it should be patented. If somebody can, for example, open up your box and see that you've got gears that are arranged in a certain way, or if they've got, a formula that can be easily reverse engineered, or you can figure out what the chemical content is to a formulation very easily, then those are the kinds of things that you need to patent. If it's like software and it's SaaS, it's stuff that's done in the cloud, and you're licensing that software, that might be something that you want to think about keeping as a trade secret. You also, for example, here's a common ones out there, the formula for Coca-Cola. Mm-hmm. They kept that as a trade secret. Only a couple of people knew that formula. They were well compensated for that. They had very strong non-disclosure agreements, I'm sure. And the company certainly has the wherewithal to get these people brought to justice and prosecuted, whereas a small company, a little startup company, maybe doesn't have that kind of money to chase somebody down and prosecute and take it through years in court if they should choose to fight it. Colonel Sanders' recipe for his chicken, same kind of thing. The formula for the cream filling in Twinkies, I think, is another one that I've heard is a trade secret. Those are the types of things that they want to keep secret because they're not easily ascertained. People can spend a lot of money trying to figure out what that formula is. Now, something that other people don't often think about for trade secrets is all the mistakes you've made to get to where you're going. You don't want to necessarily advertise that, whereas a lot of people will put it in a patent application and say, we did this and this and this, and it didn't work. And these things don't work. But we did this, this, and this, and now we've got this invention that works. Well, why would you necessarily want to disclose that to all of your competitors? All you're doing is making it easier for them to do a workaround. So that's the kind of thing you keep trade secret. I don't know. There's a number of different kinds of things like that you would just keep trade secret. Formulas, medications, those types of things, and how you get there. Processes in terms of how something is put together. There might be a very unique way to make it work properly that you have to put it together in a certain sequence. So those are the types of things that you don't necessarily put into a patent.
Great. We often hear people conducting prior art searches. When do you do those, and how much do those cost, and what's that all about?
Yeah, prior art searches, there's actually a number of different prior art searches that can be done. But the biggest thing that you want to do is take a look at your concept. And before you go spend a lot of money on a patent or on an investment, you want to go out there and see if it's ever been done or disclosed before. And it doesn't necessarily mean in a patent. It could be in a written article. Basically, anything that has been published or is made public, it can be found in any library in the world in any language, starting from the beginning of time and printed materials. If they can find it, it's prior art. So you don't want to go spend, let's just say, anywhere from $10,000 to $30,000 to prosecute and get a patent. Then you're going to spend another tens of thousands if it's a worldwide application or patent, tens of thousands of dollars maintaining that patent over the life of the patent. And then if you go to court to defend that patent, it could be $200,000, $300,000 in a protracted suit to defend your patent. Now, you could spend $1,200, $1,800, $2,000 in that range to do a good, thorough, worldwide prior art search before you've ever done anything to write a patent or file anything with the patent office. And you could find out that you have a very unique, narrow lane that you can go down that nobody's ever done before. Or you could find out that 27 people around the world at different times over the last 10 years have done the same thing. So what would you rather do? Spend a couple of $1,000s up front, or spend potentially hundreds of thousands of dollars 10 years later and possibly have an invalid patent if somebody prosecutes and takes you to court saying your idea is not unique?
And then I often hear about a freedom to operate search. What is that all about?
A freedom to operate search is something that you as an investor typically want to see. And what that is a search that's been done where you are looking at patents that are still enforceable, meaning they're less than 20 years old, or 15 depending on when they were filed, 17 when they were filed, and design patents that are 15-year life from the day of issue that still have enforceable claims. And you want to do a wide net on that in any jurisdiction where these patents are essentially going to be applied. So if you have a U.S.-only patent, then you would want to do a very broad U.S.-focused freedom to operate search that looks at every enforceable patent in that space where the product that you're investing in or the patents that you're investing in are not infringing somebody else's valid patents, either in the method of use or in the actual device that you're investing in. It's very costly if you go spend $50 or $100 or $200,000 for somebody's IP and then turn around and have somebody come and sue you 2 years later and tie you up in court for infringing, and then you have to pay them royalties for infringing their patent if they don't just shut you down, which they would have the right to do.
So what does it cost to file a patent? You mentioned several numbers there on provisionals and others, but on a standard patent, what's the all-in cost on that?
Well, the all-in cost, again, is going to depend. It depends on the technology. Software patents are typically much more expensive because it's a limited number of people that can do that, and the way that you have to now write them is much more complex than it used to be a number of years ago. Chemical patents tend to be a little bit more, that type of thing. So the all-in cost could be anywhere from for a provisional, say $3,000 to $5,000, to a utility patent that can run anywhere from $10,000 to $20,000, sometimes $25,000. And that utility patent being, anything from a mechanical device up through a drug, something along those lines. So that cost, the actual patent filing costs, are relatively inexpensive. They're $2,500, something like that, to actually do the filing for a utility application. A provisional application is like less than $500 all in, just for the filing costs. It's the time it takes for somebody to take that concept, take that idea, take that invention, and properly draft it into an application that costs money. And that's where the prices will be all over the map. Your East Coast and West Coast law firms are typically the most expensive. Your Midwest law firms, your boutique Midwest law firms in particular, are generally much cheaper. The hourly rates for a patent attorney can be anywhere from $290 to $350, all the way up to $800 or $900 an hour. And that's not at the partner level. That's just at the associate level. If you get into a partner doing the applications for you, which they rarely do anymore, they've got minions like me and junior associates that would tend to write those for them. Then they'll spend an hour going over what we've done and fine-tuning it a little bit. But those costs are typically much more expensive on the East and West Coast than they are in the Midwest.
And so how long does it take to get a patent these days?
So a patent can be done quickly. It can be done in less than a year, or it typically will take anywhere from 22 to 30 months to prosecute, all the way from the date of filing to a final determination, whether that is you get a patent or they say, nope, you don't get a patent, then you have to file with a continuing process where you pay another partial fee, not a full fee, but a partial fee, and you can actually do that 2 or 3 times. But typically it's anywhere from a standard utility patent is about 22 to 24 months. You can do a Track 1 application, which by paying a fee, everything involves a fee with the patent office, by paying a fee of anywhere from $1,100 to about $4,200, somewhere in that range, you get an expedited Track 1 application, and you can have that entire thing resolved up to and including the issuance of a patent in under a year. And that becomes critical for some industries, particularly where the life of the product may only be a few years. Software is one where that happens a lot.
Well, that's great. Well, in the last few minutes that we have here, what else should we cover that we haven't?
Well, I would say that's probably the talking points that I hit on before are probably the most critical. It's just that you should always look to file early, file often. Do your due diligence up front. Don't rely on your own skills to surf the internet to see if it's been done before. Pay someone. They're not that expensive. Pay someone who's a skilled searcher to go out there and search the databases. There are databases that you have to pay for sometimes that if they know how to access, they can get in there, they can search literature, they can search worldwide, every kind of patent, design patent, a utility patent, all those types of things, that college references, thesis, all those things. They have access to all those things, and they can find that prior art if it's out there, if it's been described, and that could save you a whole lot of money up front. That's one of the things I always recommend.
Very good. Well, appreciate the information. So how best for listeners to get back in touch with you?
Well, the easiest way to get a hold of me is through my website, Clearpat, or LinkedIn. That's always a good way to get a hold of me, or just call me. My number is 512-657-6843. I keep my phone with me almost all the time, and pretty much I'm awake from about 6 in the morning till about 9 at night where I take calls, and I'm always open for business.
Great. We'll include these in the show notes, and want to thank you for joining us today. I hope you get back for a follow-up soon.
Thank you, and thanks for having me.
Investor Connect helps investors interested in startup funding. In this podcast series, experienced investors share their experience and advice. You can learn more at investorconnect.org. Paul T. Martin is the director of Investor Connect, which is a 501c3 nonprofit dedicated to the education of investors for early-stage funding. All opinions expressed by Hall and podcast guests are solely their own opinions and do not reflect the opinion of Investor Connect. This podcast is for informational purposes only and should not be relied upon as a basis for investment decisions.